Wicker, and members of this committee. It is an honor and my pleasure to testify before you today. My name is Matt Mitten. I am a professor of law and the executive director of the National Sports Law Institute at Marquette University Law School. For more than 30 years, I've been studying and writing about various college sports legal issues, including NCAA student-athlete eligibility rules and antitrust issues, which inform my strong agreement with Chairwoman Cantwell and Senator Wicker that it is extremely important for Congress to enact federal NIL legislation for intercollegiate athletes that becomes effective on July 1st of this year. As Senator Booker stated, there's an existential threat to college sports if this doesn't happen. A nationally uniform NIL rights law, which only Congress can establish, is essential to provide all intercollegiate athletes with the same rights that will both, one, enable them to earn fair market compensation from third parties for their authorized use, and two, preserve college sports as a unique and very popular brand distinct from professional sports that currently provides very beneficial athletic and educational opportunities to hundreds and thousands of student athletes and $3 billion annually collective value of the scholarships that NCAA athletes receive. National uniformity will prevent the continuing development of conflicting and differing state laws, as well as avoid the dangers and unintended consequences of professionalizing college sports and creating competitive balance inequities, especially for a substantial structural change that will for the first time permit student athletes to receive NIL income above the full cost of their university education, and that historically courts, including the O'Bannon Federal District Court, have upheld NCAA eligibility rules prohibiting student athletes from receiving NIL income as a valid means of maintaining its amateur education model of intercollegiate sports. A federal NIL rights law requires the following three provisions to achieve these objectives. One, preemption of the proliferation of state intercollegiate athletes' NIL laws, which are establishing a patchwork of differing and conflicting rules. Neither the NCAA nor its divisions 1, 2, or 3 can establish nationally uniform NIL rights laws for intercollegiate athletics that are certain to comply with all existing and future state NIL laws. Two, a very narrow safe harbor protecting national intercollegiate sports governing bodies and their member athletic conferences and educational institutions from prospective and retroactive federal or state antitrust immunity for adopting and enforcing rules consistent with the provisions of a federal NIL law, as well as their current rules prohibiting college athletes from receiving any NIL income. Without it, the NCAA will be forced to defend continuing antitrust litigation. For example, the pending House and Oliver cases were filed almost immediately after the NCAA Board of Governors directed Divisions 1, 2, and 3 to develop rules permitting student athletes to receive NIL compensation. These cases effectively assert that providing intercollegiate athletes with NIL rights precludes the NCAA's defense of antitrust litigation based on preservation of its traditional amateur education model of intercollegiate athletics. And three, explicit clarification that, consistent with the clear weight of judicial precedent, best explained by the Marshall case, this federal legislation does not create or define college athlete NIL rights to encompass or include the use of their names or athletic performances in any media broadcasts of games or sports events in which they participate. Otherwise, the unintended consequences of permitting intercollegiate athletes to receive pay for play and the professionalization of college sports may result as plaintiffs continue to relitigate this issue. Collectively, these three requirements will ensure that the only uncertain outcomes will be during on-court college sports competition, not in-court litigation. Finally, as a faculty member at a Division I AAA university like Gonzaga, the vast majority of which provide athletic department subsidies to fund their intercollegiate sports programs, I'm very concerned that including student-athlete health and safety requirements in a federal NIL bill will substantially increase their costs and have the unintended adverse consequence of eliminating non-revenue sports and significantly reducing athletic participation opportunities at NCAA, National Association of Intercollegiate Athletics, and National Junior College Athletic Association schools. Voluntary participation in intercollegiate sports necessarily involves assumption of the inherent risks of injury. As a former chair and member of the NCAA's Competitive Safeguards and Medical Aspects of Sports Committee, I know that schools can facilitate the effective treatment of these injuries, as well as significantly reduce the risk of aggravated injury and future adverse health effects by following the committee's recommended best practices. Thank you for considering my testimony, and I welcome your questions.
Thank you very much. So obviously a lot of material put on the table here, and I think it's our task now to take you all up on the notion that everybody wants to see NIL rights and see legislation. Question is, how are we going to get that done? And obviously our colleagues have some very important viewpoints that need to be listened to. One area that I want to probe on, Dr. Frederick, you specifically mentioned the MEAC institutions and the notion that you only have limited ability to address some of these issues. Obviously, Coach Few and I would say probably the Pac-12 have been doing some of these things already and have created a standard. So we have been doing our own analysis, and to me, requiring Division I and Division II schools to help cover these healthcare costs would be an important goal for us to achieve. Dr. Emmert, what can the NCAA do now? Obviously, we heard Mr. Gilmore and others talk about the incredible amount of money that's in college sports today. What can you do to guarantee us that we could help with these institutions like Howard University or others who can't afford to have the out-of-pocket expenses that other institutions are currently handling?
Yeah, well, thank you, Senator, for the question. I think it's probably at the crux of much of this is there's general agreement, I suspect, among the panelists and others that student athletes ought not to be, as Coach Few articulated very nicely, not reaching into their pocket for covering independent expenses that are above and beyond their, or up to their deductibles, for example, in their insurance. And many of the Division I schools in the Power 5 conferences and others as well are doing so today. The question is, first of all, how would that language be crafted, and what would be the size of the cost of all of this for schools? But having said that, if the focus was on what in Division I are often labeled by the NCAA members, the low resource institutions, and those costs were simply pocket costs, doubtlessly there's a way to determine within Division I resources how to cover some of those costs. There's a variety of different vehicles for doing that. The challenge that everyone has to recognize is that there's no NCAA money, it's all the school's money, and so the NCAA serves as a pass-through. But if the member schools wanted, and I would be willing to put this question to them, to say, okay, can we find a mechanism for funding out-of-pocket expenses in low-resource schools? It's certainly a doable phenomenon. It's that the amounts of money, at least based on the modeling we've done, are not unreasonable. Where it becomes very challenging is across Divisions 2 and 3. There's probably ways to ascertain how that might be done, but the devil will be in the detail. What is it precisely that they would need to be paying for? Is it just if it's out-of-pocket expenses, meaning those costs for the deductibles of a student athlete for sports-related injuries only for some fixed period of time, that might be a manageable amount of money with the dollars that flow through the NCAA distribution system.
To me, there's a lot of money in sports, and there's going to be a lot more money in sports. I'm a big believer that as we move towards internet models, there'll be lots of ways to monetize activities. So I would hope that we could make a commitment to help Dr. Frederick's institution and other MEC schools meet those obligations so that we could move forward. I get that not all the panelists are on the same point with this, but to me, this should be an easier yes, we can get this done. I want to ask Dr. Frederick, because this issue of heat impacts and horrific news of actual deaths from this, why can't we just get better health standards to cover the NCAA institutions to set a standard for what health could be, even if it's done here at a federal level, the guidance that must be followed by institutions?
Yeah. I think this is an important point, and especially when you look around heat-related issues and concussions in particular. The NFL, for example, I think has been a model in terms of embracing this issue finally, and we have to have standards around where the athletes compete, et cetera. Once again, I think some of the issues here are around education and resources. We must insist that the number of trainers that are out there with the athletes and someone monitoring the conditions for the individual athletes are part of what is taking place. And this is not just only about heat and those things, but athletes get other issues. While I was at the University of Connecticut, there was a soccer player who I befriended who developed a testicular cancer that was metastatic. He had issues during practice that led to the discovery of this major mass in his abdomen. And as we talk about health-related expenses, his care, to UConn's credit, was taken care of fully, and he was allowed to graduate. So the other thing that I don't think we count as well is, while it does not happen often, there are issues that do impact athletes while they are in college that may not be related to their athletic endeavors that schools and colleges try to cover. And the last point I'll make is that Howard, for instance, like many schools, has a self-insured trust. And so the issue with how we cover health insurance is very different among all the institutions. And the problem with NCAA even stepping in is that for a self-insured trust, you just need one of those horrific incidents that costs you over $250,000 and triggers your excess layer. And right there, your budget, especially if it's a marginal budget. So of two of those incidents that cost $500,000 for the $14 million that we may expend is a huge deal at a Howard University. So putting into a fund, as Dr. Emmett has suggested, is potentially one way to do that. And then the last thing is somebody has to be the arbiter of what constitutes an injury during the time that you were playing versus we sometimes recruit athletes who come to us with injuries, and then subsequent to that, who's going to be the arbiter if somebody shows up 2-3 years later with a chronic issue that actually occurred before they started playing for us. We're going to need some type of arbitration around that issue as well.
Thank you. Senator Wicker.
Well, thank you very much. And it's obvious that all 6 of these witnesses have put a great deal of thought into very excellent testimony. I really appreciate the efforts there. Let me start with you, Dr. Frederick. You come down on the side of a uniform national standard on paying, on allowing name, image, and likeness compensation. How would a patchwork of 51 different laws impact recruiting and fair competition among universities within your conference?
Yeah, I'll give you 2 examples. One is a personal example. I'll take my son to Philadelphia this weekend and play in a soccer game. Several coaches are going to look at him there. The coaches that are looking at him from North Carolina and New Jersey have 2 very different approaches. I got on Zoom calls with both sets of coaches. One set is talking about NIL rights. My son and I have no clue about his image he's going to market. And the other coaches are talking strictly about academics and his competition in school. So already, just as a parent, it is extremely confusing if you have 51 states with different laws as you're looking at schools trying to decide what type of experience your student would have. And then on the recruiting side, as a college administrator, I can tell you, we just started a Division I golf team. We have a young lady who has committed to us, and I know more about her clothing brand than her clothing company than I do about her golf game or her academics, because the recruiting atmosphere around that is very, very different. So our ability to compete in DC, where there is no such law and no such guidance, is going to be impossible as we try to recruit someone like that to us. And I mentioned McCurr Maker, who is the only five-star basketball player that has come to an NCAA school. One of the challenges to an HBCU, one of the challenges we had in recruiting him was exactly that, the fact that soon enough laws were going to come to pass that would have left us unable to compete with other states where schools would have been able to offer him the opportunity for NIL.
Well, let me turn to Coach Few on the same thing. Now, Coach Few, the state of Washington does not have a state statute. Can you take a minute and tell us how that's going to affect your recruiting, or how that is affecting your recruiting?
I mean, it's in some ways it's impossible to project, but I mean, it in many ways it isn't. It will never be the same. I mean, we recruit nationally, even internationally, and you know, to not have the ability to compete on some sort of level playing field with people that can provide, you know, monetary gifts or endorsements or things like that would put us in a disadvantage that we couldn't make up. And I don't think the story of Gonzaga playing in 2 national championship games would ever happen if this was around prior.
Mr. Gilmore, you seem to be outnumbered on this panel 5-1, and I'm sure you're equal to that task. But your response to Coach Few, I guess, would be that's a decision that the duly elected leadership of the state of Washington made, and we ought to see how this plays out. I want to give you an opportunity, since it seems that 5 members of the panel have another view. Would you like to weigh in and respond to their testimony in that regard, with regard to the patchwork?
Of laws issue, I think we lose sight of the fact that the NCAA is operating a national business, and that is not unique in the United States. We have businesses every day that are forced to comply with laws in various states, and they do it quite well, and it hasn't created crazy chaos. There is some uniformity that is nice, that would certainly work for the NCAA. We understand that. But what seems to be coming across is a reluctance to participate fully in a free market and to have protections from a free market. And as you mentioned with the state of Washington is free to decide that they do not want to have laws that relate to name, image, and likeness, while Oregon next door may decide that they do, and that will have an impact on recruiting. We have seen in the last few months that what has happened in this era where states are making decisions about NIL, we have seen coaches and athletic directors and presidents go to state legislatures and say to them, hey, look, I want to be able to recruit effectively against my neighboring state, so we need legislation. And the market has been responding and providing that. So there is no doubt in my mind, and I think historically when we look at how markets have operated, that there will become some sort of equilibrium without the need for uniform law. I'm not against a uniform law. It's just that if we're going to have a uniform law, it needs to be very thoughtfully done about how we are helping players. For example, we talk a lot about guardrails, and the guardrails seem to be there to protect the NCAA and the institutions. We want to protect them from the marketplace. For example, you heard testimony earlier about, well, athletic departments should be protected against contracts that may conflict, where a player can't have a contract that the athletic department has with a similar entity. Well, that's a market protection, and private parties normally can handle that with exclusivity. If the athletic department has the ability, let's say with an apparel company, to say you won't make a deal with any players, they can negotiate that. But to protect the revenue stream for the athletic department, and for example, say that a player cannot have, just to use an example, an agreement with Nike or Under Armour because the athletic department has one, is really prohibitive and isn't fair. It's a market protection for the university. And it very well may be that those contracts could coexist with players having the right to that kind of a sponsorship, but wearing the required university attire during university events. So the protections are a concern for me. And I also want to go back and address the cost issue for protecting players with health insurance. We seem to keep talking about this on an individual level for schools, and I was pleased to hear Dr. Emmert talk about some possibility of some funding and revenue sharing. I think we need to remember that this is an overall enterprise which the NCAA and its member institutions have engaged in sports, and sometimes very dangerous sports. And they have this responsibility, one, to protect their players, and two, to comply with Title IX. And they ought to be charged collectively with making sure that that is done, and not simply whether you've got one rich school that can afford it and then another school that can't afford it. The NCAA and the member institutions have collectively decided that they want to be engaged in this, and at the very least, players should have the health care, the protection to know that they're safe in practice, and that when they're done playing, if they have chronic injuries or they have injuries that resulted from their playing, that they are protected. And it should not be simply said that, well, your university can't afford it.
Thank you. Thank you, Mr. Gilmore. And for colleagues, I have been pretty liberal today for various reasons of allowing people to go beyond their 5 minutes. But if members could help us out, because we have a number of members and I want them to get their questions in, and if people answering questions could also help us out there, that would be great. My colleague, Senator Blumenthal.
Thanks, Chairman Cantwell, and I'm really grateful for your leadership as well as your having this hearing today. You have been really extraordinary in pushing forward toward a bipartisan consensus that I think is within reach. I want to thank the ranking member as well for his leadership. Today is a banner day for Connecticut. We have become the 19th state to pass an NIL law, which we expect the governor to sign shortly. What we're seeing is a chain reaction of states filling a gap in protecting people. It is classically what happens in our federal system. I've been at consumer protection for 3 decades now, and this historical pattern is repeated every time, where states fill a gap and then a national standard is sought by a group that fears a patchwork. And I will tell you that I will oppose and help to block any NIL standard that is weaker than Connecticut's. I expect this Congress should block any NIL standard that is weaker than the strongest state standard. And we need to listen to the athletes. They are the ones who are all too frequently outnumbered in this conversation. And if you listen to the athletes, what they will tell you is they want more than just to be shown the money. They want more than just NIL. They want a strong, enforceable standard for health and safety and educational opportunity, because the overwhelming number of athletes in this country will never make a lot of money off NIL, but all too many of them will suffer life-changing injuries or deprivation of educational opportunity and other kinds of harm that we're seeking to pretend and protect against. Let's be very real here. The NCAA is at the table only because it's been hauled, kicking and screaming here. after dithering and delaying too long. And they're here only because they fear that patchwork. The states are, in effect, running to the top. The NCAA, in its rules, nothing personal, Dr. Emmert, is racing to the bottom common denominator. And we have to avoid that happening. So I want to ask you, Dr. Emmert, taking your testimony here, and you've heard the statistic about 30 college football players dying from non-traumatic causes during workouts in 20 years, compared to only 1 in the NFL. Would you agree with me on behalf of the NCAA that schools that violate safety standards, especially intended to prevent concussions and heat stroke, should face enforcement actions with financial and operational consequences? That's part of what we believe is necessary in a college athlete's Bill of Rights.
Well, first of all, thank you, Senator. I think the questions that you and others have been raising about healthcare are obviously central to what the NCAA is about and what it was created for more than a century ago. If I might just make sure everyone understands, there are indeed science-based standards around many of the issues that were being talked about, including how to treat heat-related disorders, how to deal with concussions,
You know,
et cetera.
I apologize for interrupting, but
quite all right.
you know, my time's limited. I think it's a yes or no answer. I hope the answer is yes. You do believe in such stands.
I believe there needs to be some system by which schools are well educated, well aware of, and are expected to behave in a manner consistent with all the best medical practices out there.
Let me ask you, the Drake Group has called the NCAA's rules on sexual assault, quote, toothless, end quote, and, quote, woefully inadequate, end quote. There is a crisis of sexual assault in college sports. What's at stake here is more than just money. It's fairness and dignity, racial justice and gender equity. My hope is that the NCAA will commit to those principles as well.
Absolutely.
And Dr. Fredericks, because my time is limited, I'm going to be real quick in this question. You've expressed very understandable concerns about the cost impacts of these standards. The answer is very simply cost sharing. Some schools are rolling in money as a result of this almost $20 billion industry. If they share some of the cost of schools like Howard or others that are not profiting in the same way off the blood, sweat, and tears of athletes, wouldn't that allay some of your concerns? Thank you. Madam Chair, I'm going to observe your admonition and end my question there, but I'll pose some additional questions in writing.
Thank you for that. I appreciate that. Senator Moran.
Chairman, thank you. Thank you to Senator Thune and Senator Fisher for yielding to me to go next. And thank you, Chairman and Ranking Member, for this panel. This is one of the better panels, one of the best panels we've had on, certainly on this topic, but just generally in front of the Commerce Committee for a long time. Everyone has added to the debate and to my knowledge, and I think to my colleagues' knowledge. And while Senator Blumenthal sounded very vociferous there, he still remains my partner and colleague in trying to find a bipartisan compromise so that we can get something done. My view is that over the years, college athletics has grown into an increasingly profitable billion-dollar industry, but the rules surrounding athletic compensation has not kept pace. And I'm of the view that it absolutely needs to change. I believe it's important that we empower amateur athletes to capitalize on their name, image, and likeness. However, at the same time, I want to ensure the integrity of what I guess is called the collegiate model, but what it means to me is that we afford the opportunity for many student athletes to receive an education. And if we don't do this right, those who receive the compensation from NIL may benefit at the demise of those who are playing in sports that are not, quote, profitable, and those who have no capability, therefore, of capitalizing on name, image, and likeness. And it seems to me that we know that college basketball and college football generally subsidize other sports and the athletes who get to participate in those programs. I've introduced a bill that is not necessarily the ideal bill, even for me, the Athletes Protection and Compensation Act, but it's designed to find something that is the sweet spot that brings sides together and try to meet a July 1 deadline. Let me ask, first of all, on this July 1 deadline, Mr. Minton, I want to visit with you, Professor. You started down a sentence. I thought you were going to end your sentence differently than you did, so I'm going to ask my question as the way I thought something you were going to say. As state laws go into effect and student athletes begin to hire agents, sign endorsement deals, and monetize their NIL, these athletes, then what happens on the occurrence if we're not have a law in effect by July 1? Student athletes and student college athletic programs progress under their state laws. They begin to adapt and comply with those laws. And if we fail to act by July 1, what confusion or challenges do we face, or do the athletes face, or the program? So my question is designed to elicit an answer about the importance of the July 1 deadline for Congress to act.
Thank you for that question, Senator. You know, the essence of sports is that everyone plays by the same rules. It's not only rules of the game, eligibility, but in this context, all student athletes nationwide, regardless of sport, should have exactly the same NIL rights. Not every state recognizes name, image, and likeness rights, are often known as the right of publicity. There's only roughly 30 or so. There are going to be, as you know, others on this panel, including Coach Few mentioned, there's going to be a competitive advantage provided to certain schools. That's one thing that's very problematic. That's one of the other hallmarks of sports, is the uncertain outcome. It distinguishes sports from other forms of entertainment. So we certainly need to have that. So that's what I would say, is that it's just, the cat is going to be out of the bag, so to speak.
How do you put the cat back in the bag after July 1?
I don't think you can. I think that is exactly the problem. And Congress has to come up with, what's going to be the rule? Everyone plays by the same rules across the board. That's what I think is the most critically important thing.
Let me turn to one other topic in this venue of topics related to NIL. Commissioner Gloria Navarez of the West Coast Conference recently wrote that revenue sharing in college sports would be, quote, disastrous for women's sports. She went on to note that even though the WCC had won 9 national championships in soccer and 6 in tennis, men's basketball programs like that of Mr. Few's at Gonzaga, this is my words, not hers, quote, pays the lion's share of the cost of every other opportunity we provide in every other sport. The simple reality is that the only sports that generate necessary revenues to be self-sustaining are football and men's basketball, and all other sports rely upon those 2 sports to fund their operations. Dr. Fredericks or others, how do you think that the distribution of athletic revenue directly to student athletes would affect collegiate athletics in general?
It will impact it very negatively. Like I said, Howard has the only swim team at a historically black college and university. We have other minor sports that we will not be able to maintain if it becomes unequal, and especially in terms of recruiting, because as we talk about revenue, the television revenue that we generate is minuscule compared to these other.
Which will diminish the opportunities for all athletes, black, white, women, male, female. There's a consequence here more than just how we effectuate taking care of those athletes that can earn revenue based upon their name, image, and likeness, correct?
That's exactly right, because those athletes, if they would, that NIL, they will gravitate to certain areas. I know there's a discussion about other talents outside of athletics, but the reality is the bulk of where they will gravitate will be to the Power 5 and the bigger schools where there's a media market.
Thank you. Thank you,
Thank you. Senator Schatz.
Thank you, Chair Cantwell and Ranking Member Wicker, I want to thank all of the testifiers. This is a new issue for me, so please bear with me. I have just a tactical question for us in the next 3 weeks. If we're trying to enact a national NIL standard, Dr. Emmert, I'm trying to figure out why we would also try to complicate this matter by providing immunity against claims from former students. Like, what's that got to do with the subject at hand?
Well, thank you, Senator. It's a critical issue, as you've heard from a number of us. The reality is that there has been in the past, and there already is in place, a series of legal challenges that have, in my terms, fallen under the no good deed goes unpunished clause. And that means that as soon as, indeed, the Board of Governors told all of the divisions to begin to think through passing NIL rule changes at the NCAA, we immediately had lawsuits filed for our failure to have done so in the past. And those are 2 suits that are already pending as we speak. We want to do the right thing here. You've heard from everybody in this panel that passing an NIL bill at the congressional level is critical to moving forward, in part because we want to get this done and we want to do it and not be then immediately sued for having done the right thing in this case.
Professor McCann, you want to weigh in here?
Yeah, thank you, Senator. There are certain legal issues that would arise if Congress doesn't take action, and one would be the relationship between the NCAA and its member schools would vary by state. And in the past, and I'm not going to speak for President Emmert, but in the past, the NCAA has brought litigation over that issue. About 30 years ago, there was a case in Nevada that I mentioned earlier that if one state has one set of rules and another state has another, it interferes with the relationship between the national organization and its members. So I think that some type of national rule that is clearly the rule would mitigate that risk. Now,
what's that got to do with indemnifying the NCAA for past violations? I don't get it.
Sure, and I would separate those 2 things.
Okay, that's all.
Yep, I would separate those 2 things.
Now, Dr. Emmert, is the NCAA planning, if Congress doesn't act soon, to file injunctions against states with NIL laws?
We've not taken that position yet. That decision would be up to the Board of Governors, a representative body of university presidents, but so far that decision has not been made.
Could you give me a sense of your decision-making process? Do you have a lean? Have you considered it? Is this under discussion?
It's been widely discussed, as you can imagine, but again, there's not been any decision made.
I get that there's no decision made, but you're here, and I'm asking you, what are you going to do? And I'd like you to give me a little clarity on where you are. It's absolutely true that procedurally you haven't decided. I'm asking you whether it's likely or not, what your thoughts are on this.
Again, it won't be my decision, it'll be the Board of Governors' decision, but I believe that for universities themselves to file lawsuits against their own states is a very challenging thing to do.
Okay, final question for Professor McCann. As we consider this legislation, the NCAA is asking to, in their words, clarify that athletes are not employees. The implications here, I mean, it sort of sounds benign and it even sounds logical to a certain extent, but the implications here are pretty significant. OSHA wouldn't have jurisdiction, EEOC wouldn't have jurisdiction, NLRB, the Department of Labor's Wage and Hour Division. That seems to me to be a massively consequential choice here, and again, separate from the question of NIL. And I guess what I'm observing here, not an expert in this space, but an expert in legislative politics, if you will, is that Dr. Emmert is asking for a really big trade in exchange for a national NIL standard. And I don't think we're prepared to do that in terms of executing on it. And I'm not sure that these things are on point with the narrower question of NIL, and I'm wondering if you can comment there.
Yeah, I don't view that as a clarification. I view that as a massive change. I don't see the need to declare that college athletes are not employees. I think that's a separate issue from NIL. Moreover, that's an issue that has been addressed by the National Labor Relations Agency, NLRB, excuse me, and also the National Labor Relations Act. This is also an issue that varies by state, where some public universities and private universities are governed differently under that question. I don't see the need to address that in an NIL bill, just like I would say other things that we've talked about are separate from an NIL bill. Yeah, I don't view that, with respect, Dr. Emmer, I do not view that as a clarification. I view that as a massive change.
Thank you very much.
Thank you. Senator Thune.
Thank you, Madam Chair, and welcome. Thank you to the panel. This is a complicated subject and one that I really wish the NCAA would have been able to figure out, because, you know, there's certain things the federal government does well and certain things the federal government doesn't do well. This strikes me as something that we may not do well. And so I'm interested in hearing from you about what you think a proposal that should become law, if that's what we have to do, given the fact that states are now acting in the absence of NCAA action. And obviously, conferences don't follow state lines. We've got lots of multi-state conferences that could have different laws in place. So it seems to me that, you know, now we're in a position where we have to do something. But what we do is still a point of discussion. There are a couple of proposals I think you may be aware of that have been introduced by members of the Senate. I'm interested in your thoughts about either or both of those, and there may be perhaps others, but more than anything else, I just think that you're in a much better position to guide this process in terms of what a potential set of rules might look like than maybe we are. And but I've been very interested in this discussion we're just having about employer-employee, and I think Dr. Emmert, you mentioned that in your written statement at least, that you didn't think that you couldn't support anything that would essentially create an employer-employee relationship. And I would just ask you to sort of reiterate your view on why that's something that you prerequisite for legislation.
Yeah, thank you, Senator Thune. The issue of employment status versus being a traditional student athlete, as that's been defined historically, is really at the core of what college sports is all about. If student athletes are classified as employees of their university, their college or university, it is, as Senator Schatz pointed out, it does change very fundamentally the nature of that relationship. It moves student athletes out from underneath the guise of education law, for example, to employment law. I believe that's what the good senator was alluding to. And for one, that means Title IX is no longer relevant to college athletics because that's education law, not employment law. It changes the relationship between Coach Few and as a student athlete says coach-student to employer-employee. It changes everything about what college sports really is and why we have created college sports 120-some years ago. So everybody in higher education sees that question as one of the core issues to defining college sports versus professional athletics.
So, and just again, by way of, I come from a state, we don't have, we have two mid-major universities and a number of Division II schools in South Dakota. And you've touched on this a little bit, I think some of you have in responses to questions already. But how do you see this playing for a University of South Dakota or a South Dakota State University where you've got a mid-major program, the transfer portal already, which I think is very much a benefit to athletes, makes it harder, I think, for a lot of those types of schools to keep athletes, retain athletes once they get them there. But how will this affect recruiting athletes, and does it put those types of universities at a competitive disadvantage relative to a Power 5 conference?
Well, I think, first of all, Coach Few could answer part of that question very, very, very well. I think especially with the patchwork that we're going to see starting July 1, those schools that are in states that allow name, image, and likeness opportunities are going to have an enormous advantage in the transfer portal as well, because student athletes will indeed be looking for opportunities to transfer to schools where they can monetize their name, image, and likeness. It's one of the reasons we need, of course, the nationalized rule. The second component is we need those set of guardrails that we've been describing so that students can monetize their name, image, and likeness, but it's not being used as a recruiting inducement. Absent some guardrails, coaches and others will in the recruitment process be including in their recruitment pitch a specific opportunity for a specific contract or a specific endorsement deal at a specific place. That's precisely what we want to avoid. And the legislation that's been discussed here in this chamber has always included those kind of guardrails.
Coach, any comments on how it will impact?
Thanks, Senator. Absolutely. I mean, the impact would be enormous. And if you were from a state like South Dakota or Washington, you would be put at a huge competitive disadvantage and one that would be very difficult to make up, both when the student athletes are coming out of high school, but also, you know, as they have the opportunity to transfer. And, you know, speaking to Dr. Emmert's point, you know, having some sort of parameters in line so we can keep some sort of semblance of competitive equity in recruiting, you know, where we're talking about, you know, each of us being able to give a similar experience to these players, and it not turning into basically a bidding war where it's just monetarily based.
And that's what I'm afraid what could happen and what we obviously have to avoid. And Madam Chair, again, I would say I think it would be a benefit to all of us to hear specifically from people who I consider to be experts who deal with this every day, what they think this might look like if we are to legislate on this. And it sounds like from a time standpoint, we don't have a lot of time. We need to come up with something in fairly short order. So I hope we can get working on that right away.
Thank you. Thank you, Senator Thune. Senator Tester.
Thank you, Senator Cantwell. And I want to thank the panel for being here today. I appreciate your commitment to making sure that not only do we have a good opportunity for student athletes, but we have good universities behind them. Dr. Emmert, thank you for being here. Thank you for the conversations we've had before. I'm sure that the NCAA has monitored probably all 19 of the NILs that's coming out of the recent states. Can you, and I don't want to spend all day on this, but can you tell me one that's particularly unworkable?
There are various, first of all, good afternoon, Senator, good to be with you again. But the corpus of the state laws around what can be included in NIL is largely similar. There are other elements around them that are highly disparate. And some of them, for example, allow third parties, independent third parties, to provide cash benefits to student athletes for a variety of their personal needs. That would be extremely disruptive to the recruitment system that Coach was referring to.
Okay, so I think it's a little different than most laws when done by a state. And I'll tell you why, because I think that there's some opportunities here. Sports is important, probably more important than it should be. Okay, but you have a state, I don't want to pick any schools, but you know, one of the big boys, and the state legislature can make this law so it gives them an incredible recruiting advantage in the overall mix of things. Would you agree with that?
Absolutely, and we're seeing that play out in reality.
And so would you also agree then that if we were to do a national bill that would apply evenly across the board, so it wouldn't be a patchwork, that would be something that could help our student athletes and help the universities behind them?
I think it's the only sensible approach to this. So yes, indeed, I do.
So I want to go back to another thing and that deals with health and safety measures. I am told that they're voluntary currently. Is that true?
There is not an enforcement system in place at the national level. Every university is expected to follow all of the health and welfare protocol that are in place. And when they fail to do so, it's usually dealt with at the institutional level and at the state level.
And I would just say that hopefully the NCAA is monitoring that and giving some advice because quite frankly, you got an 18, 19-year-old kid that doesn't know fully how his body works anyway, or her body works anyway, and to be put in positions they might not know when their body is truly in distress, okay?
Yes, we do very much that.